Good evening, all. The Supreme Court observed in its latest judgment, that is Yogesh Upadhyay and others versus Atlanta Limited, that the non-obstante clause in Section 142, Clause 1 of the Negotiables Instrument Act merely refers to the manner in which the cognizance is to be taken for offences under Section 138 of the Act of 1881, and it does not exclude the power of the court to transfer pending criminal proceedings under Section 406 of the CRPC for offences under Section 138 of the Act. And so, moving on to the case, the facts are that six checks, which are the subject matter of the complaint cases, were issued by the petitioners in connection with the purchase of a crusher plant from Atlanta Limited. The sale consideration was to be paid in seven installments by way of checks. The first check was duly honored and paid, but the remaining six were not put off. And this was due to the stop payment instructions. The first two checks that were dishonored were presented by the Atlanta Limited through its bank in Nagpur, Maharashtra, resulting in the first two complaint cases being filed in Nagpur. However, the remaining four checks were presented by Atlanta Limited through its bank in New Delhi, resulting in the other four complaint cases being filed in Dwarka. And so the petitioner seeking the transfer uh, of the two complaint cases pending before the Nagpur Civil Court to New Delhi to be tried along with four other complaint cases. And so the argument that is presented here was that the petitioner contended that since all the checks are related to the same transaction, it is appropriate to try and decide the cases together. So the respondent opposed the petition on the ground that Section 142 of the Act of 1881 overrides Section 406 of the CRPC due to the non-obstante clause in it, and therefore the two cases filed at Nagpur cannot be transferred. So he has asserted that Section 142, Clause 2 of the Act of 1881 gives exclusive jurisdiction to the courts of Nagpur for the first two complaint cases. So the things that were observed and held were that the Supreme Court firstly observed that the statement of objects and reasons of the Amendment Act 26 of 2015 makes it clear that the insertion of sections 142 clause 2 and 142a in the act was a result of the judgment in Dashrath Roop Singh Rathod versus State of Maharashtra. The phrase that was used was shall be inquired into and tried only by a court within whose local jurisdiction in section 142 clause 2, and this is contextual to the ruling in the aforementioned case of Dashrath Roop Singh, that the territorial jurisdiction to try an offence under section 138 vests in the court having jurisdiction over the drawee bank and not the complainant's bank. Therefore, section 142 clause 2 makes it clear that the jurisdiction to try such an offence would vest on merely in the court within whose jurisdiction the branch of bank, the branch of the bank where the check was delivered for collection is situated. And Section 142A further validates and reinforces the transfer of pending cases to the courts conferred with such jurisdiction after the amendment. The Supreme Court referred the case of Bridgestone India Private Limited versus Inderpal Singh and upheld that the non-obstante clause in Section 142, Clause 1 of the Act of 1881 does not override the entirety of Section 406 of the CRPC, and it is permissible for the court to transfer complaint case under the power of Section 406. The non-obstante clause in Section 142, Clause 1 merely refers to the manner in which cognizance is to be taken for offences under Section 138 of the Act, and it does not exclude the power of the court to transfer pending criminal procedures under 406 of the Criminal Procedure Code for offences under Section 138 of the Opposing Act. And the Supreme Court further held that the power to transfer criminal cases under Section 406 remains intact in relation to offences under Section 138 of the Other Act of 1881, and it is found to be expedient for the ends of justice that this must be a case that should be followed. The court observed that the non obstante clause in Section 142, Clause 1, merely has reference to the manner in which the cognizance is to be taken. And those were the elements of my analysis. Thank you.